Supreme Court rules Trump cannot block release of financial records. Two rulings cleared the way for prosecutors in New York to see President Trump's financial records, but the justices stopped Congress for now. The Supreme Court on Thursday cleared the way for prosecutors in New York to see President Trump's financial records, a stunning defeat for Mr. Trump, but a decision that probably means the records will be shielded from public scrutiny under grand jury secrecy rules until after the election, and perhaps indefinitely. In a separate decision, the court ruled that Congress could not, at least for now, see many of the same records. The vote in both cases was 7-2. Chief Justice John G. Roberts Jr. wrote both majority opinions. The court's decision in favor of the New York prosecutors was a major statement on the scope and limits of presidential power, one that will take its place with landmark rulings that required President Richard M. Nixon to turn over tapes of Oval Office conversations and forced President Bill Clinton to provide evidence in a sexual harassment suit. In the case concerning the prosecutor's subpoena, Chief Justice Roberts wrote that no citizen, not even the president, is categorically above the common duty to produce evidence when called upon in a criminal proceeding. He added that Mr. Trump may still raise objections to the scope and relevance of the subpoena. The court's four more liberal members joined that majority opinion, and Mr. Trump's two appointees, Justices Neil M. Gorsuch and Brett M. Kavanaugh, voted with the majority, but did not adopt its reasoning. How the court ruled: the court ruled in two cases, 7-2, that President Trump can for now block the release of his financial records to Congress, but that prosecutors in New York may see them. In the case concerning congressional subpoenas, Chief Justice Roberts wrote that lower courts had not adequately considered the separation of powers concerns raised in the case. He was joined by the same justices who voted with him in the New York case. Justices Clarence Thomas and Samuel A. Alito Jr. dissented in both cases. Mr. Trump immediately attacked the outcome on Twitter. "This is all a political prosecution. Courts in the past have given broad deference. But not me," he wrote. Mr. Trump had asked the court to block both sets of subpoenas, which had sought information from Mr. Trump's accountants and bankers, not from Mr. Trump himself. The firms have indicated that they would comply with the court's ruling. Mr. Trump's lawyers had argued that he was immune from all criminal proceedings and investigations, so long as he remained in office, and that Congress was powerless to obtain his records, because it had no legislative need for them. Sekulow, a lawyer for Mr. Trump, portrayed the decisions as at least a temporary victory. "We are pleased that in the decisions issued today, the Supreme Court has temporarily blocked both Congress and New York prosecutors from obtaining the president's tax records," he said in a statement. "We will now proceed to raise additional constitutional and legal issues in the lower courts." House Democrats and New York prosecutors said the records may shed light on Mr. Trump's foreign entanglements, possible conflicts of interest, whether he has paid his taxes, and whether his hush money payments violated campaign finance laws. One of the cases concerned a subpoena to Mr. Trump's accounting firm, Mazars USA, from the office of the Manhattan District Attorney, Cyrus R. Vance Jr., a Democrat. It sought 8 years of business and personal tax records, in connection with an investigation of the role that Mr. Trump and the Trump Organization played in hush money payments made in the run-up to the 2016 election. Mr. Vance expressed satisfaction with the ruling in his favor. "This is a tremendous victory for our nation's system of justice, and its founding principle, that no one, not even a president, is above the law," he said in a statement. "Our investigation, which was delayed for almost a year by this lawsuit, will resume, guided as always, by the grand jury's solemn obligation to follow the law and the facts, wherever they may lead." Both Mr. Trump and his company reimbursed the president's former lawyer and fixer, Michael D. Cohen, for payments made to the pornographic film actress Stormy Daniels, who claimed that she had an affair with Mr. Trump. On the other side, USA Today wrote, Supreme Court gives Native Americans jurisdiction over eastern half of Oklahoma. The Supreme Court ruled Thursday that the eastern half of Oklahoma can be considered Native American territory, a decision the state previously warned could create civil, criminal and regulatory turmoil. The 5-4 decision was written by Associate Justice Neil Gorsuch, and joined by the court's 4 liberal justices. The justices were considering the issue for the second time, after failing to decide a different case last year, when Gorsuch was recused and the court likely deadlocked. The case concerned an appeal from Jim C. McGirt, a Native American, who claimed his state rape conviction from 1997 should be overturned because Oklahoma lacked jurisdiction. Congress, his lawyer Ian Jashingran said, never properly terminated the reservation. During oral arguments in May, the justices reached back to 1907 to determine whether Congress, using imprecise language, failed to disestablish the 1866 boundaries of the reservation. If so, virtually half of Oklahoma, home to 1.8 million residents and including Tulsa, where President Donald Trump recently held a controversial campaign rally amid a global pandemic, would remain Native American territory. That means Native Americans are subject to federal, not state, laws. In reaching our conclusion about what the law demands of us today, we do not pretend to foretell the future, and we proceed well aware of the potential for cost and conflict around jurisdictional boundaries, especially ones that have gone unappreciated for so long, Gorsuch wrote in Thursday's decision. But it is unclear why pessimism should rule the day. With the passage of time, Oklahoma and its tribes have proven they can work successfully together as partners. The federal government promised the Muskogee Creek Nation a reservation in perpetuity, Gorsuch wrote, adding that while Congress has diminished the sanctuary over time, lawmakers had never withdrawn the promised reservation. As a result, many of the arguments before us today follow a sadly familiar pattern. Yes, promises were made, but the price of keeping them has become too great, so now we should just cast a blind eye. We reject that thinking. Chief Justice John Roberts, in a dissenting opinion, said that Congress made no attempt to conceal its intention to disestablish reservation lands. The court suggests that Congress sought to tiptoe to the edge of disestablishment, Roberts wrote. Quite the opposite. Through an open and concerted effort, Congress did what it set out to do: transform a reservation into a state. Roberts wrote that the Creek Nation territory has been repeatedly described by the nation and by the courts as former reservation land. Yet today the court concludes that the lands have been a Creek reservation all along, contrary to the position shared for the past century by this court, the United States, Oklahoma, and the Creek Nation itself, Roberts wrote. The state Solicitor General, Nathan Mancingani, warned that could require the release of more than 1,700 inmates. That didn't sit well with several justices who feared a chaotic overhaul of long-decided criminal cases. What makes this case hard is that there have been hundreds of prosecutions, some very heinous offenses of the state law. On your view, they would all become undone, Associate Justice Ruth Bader Ginsburg told Jushingern. Won't residents be surprised to learn that they are living on a reservation, and that they are now subject to laws imposed by a body that is not accountable to them in any way? Associate Justice Samuel Alito asked. In the earlier case, the U.S. Court of Appeals for the 10th Circuit ruled the state lacked jurisdiction to prosecute a gruesome murder because it happened within 3 million acres belonging to the Muskogee Creek Nation. The ruling threatened more than 19 million acres in eastern Oklahoma, once inhabited by 5 Native American tribes. Yet many Oklahoma public officials, including Republican Representative Tom Cole and former Democratic Governor Brad Henry, urged the justices to rule in favor of the Native American tribes whose sovereignty, they said, has been good for the state. In one area after another, taxation, gaming, motor vehicle registration, law enforcement, and water rights, the nation's sovereignty within their reservations, and the state's recognition of that sovereignty, have provided the framework for the negotiation of intergovernmental agreements that benefit all Oklahomans, they said. The Trump administration took the state's side, telling the justices that Congress long ago broke up the Creek Nation's lands, abolished its courts, and set a timetable for the tribe's dissolution. Last year, 10 states from Maine to Texas to Montana warned that the boundaries of tribal lands have jurisdictional consequences there as well. They said a decision in the tribe's favor would be confusing and costly at best, and disastrous at worst, affecting health and energy policy, environmental regulation, economic development, and taxes.